minute just for other people to join the sessions. But in the meantime, let me just sort of start with a bit of housekeeping. Welcome everybody to this webinar on the cohabitation claims and property disputes for unmarried couples. This is an update for family and private client lawyers, delivered by Andrzej Bojarski from the 36 group. The session is one of a variety of webinars available free of charge to Surrey Law Society members over the course of the year. Just for a quick one, housekeeping displayed on screen. If you have any questions that you'd like the speaker to answer during the webinar, you can ask this by using the Q&A facility within Zoom. If you'd like to speak to Andre at the end of the session, you can request to do this by using the raise hand function, and this webinar will be recorded, so please bear that in mind. But it also means that you can access it afterwards, so it is available to all members after the event. Just a quick introduction to me. I'm a chartered financial planner at Eveling Partners. Formerly we were HFS Milbourne, if you remember that firm, based in Guildford, as is the Eveling Partners Guildford office. We look after private client work, employee benefits, and now have the benefit of professional services. So all sorts of tax specialisms if you need that, particularly in the space for, we have a chap, Adam Smith, I think you may know him, who specialises in international circumstances such as US citizens, and can do joint expert reporting on such matters. We are Financial Conduct Authority regulated, provide the full range of services such as financial planning, investment management, and in that regard we are completely whole of market. Next slide please, Helen. The business, when we were HFS Milbourne, we looked after about 500 million of funds. Eveling Partners is now sort of top 6 in terms of wealth management businesses. We look after 55 billion pounds worth of assets for our clients. There's 265 financial planners such as myself, 290 investment managers, and we've got offices throughout the country. So quite a big business, lots of awards there that speak highly in terms of the service that we can provide to our clients. So just moving on now to the session today. Cohabitation claims and disputes can often arise on the course of matrimonial litigation and for private client lawyers in the context of administration estates, as well as upon the bankruptcy of individuals. This webinar will cover the following: constructive trusts, a review of developments in the case law since the landmark case of Stack and Dowden and Jones and Kernott. We'll be looking at proprietary estoppel, the latest case law, guidance and examples of how the courts are dealing with these claims. How do the rules differ between a home and an investment property? Equitable accounting, how does it work? And then a procedural update, developments in the CPR and cost budgeting, which you need to know about. Andrzej Bojarski is a barrister, mediator, both in civil and family, and a family law arbitrator. He specialises in the financial aspects of family relationship breakdown, particularly in high value, complex and international cases. So I think we've got an excellent speaker today to walk us through this complex subject. Over to you, Andre.
Thank you very much, John, and thank you, Surrey Law Society, for inviting me to speak, and to all of you for attending. So we've got quite a lot to go through. John described it as a walkthrough. We might at stages be galloping rather than walking, but there's a lot to get through, so let's get straight to it. Let me just get my slides so you can follow what I'm saying on screen. And I'm hoping that once I've finished this afternoon, I'll be able to get these to the administrators at Surrey Law Society so they'll be able to circulate them so you've got them for reference. So as John has just outlined what we're going to cover, that we're going to deal with trusts and proprietary estoppel just in terms of a little recap and looking at what the latest case law tells us in relation to those areas. Have a little think about how the law deals with assets other than the family home, which obviously the leading cases tend to focus on. Then briefly just have a review of equitable accounting and related principles in terms of how they now work. And then for much of the sort of second half, last third of the talk, we'll have probably where we really run into a brisk jog, if not a gallop, a review of the procedural rules as they are, particularly for those of you who probably spend most of your time either not doing litigation work or not doing litigation within the CPR, but using the FPR instead. So let's just begin with a couple of key points to remember, really probably aimed more at the family lawyers amongst you than the private client lawyers in terms of how the law looks at these questions. Obviously, unlike the Matrimonial Causes Act, we're dealing here with strict property and trust law principles which determine the ownership. And so the court's discretion to do what it thinks is fair is obviously much more limited than it is in the context of a married couple. Bear in mind, and we'll look at the case in just a moment, that whether you've got an express declaration of trust, which in most joint names purchase cases these days tends to be the case, that's likely to be pretty much the end of the story. But if you've got a case where you haven't got an express trust, or you've got some debate as to whether the terms of that trust have been varied by reason of what the parties have done since the property was purchased in joint names, the key is going to be looking at intentions. And that's really looking at what's been said or what's been agreed between the parties, looking at what the behavior tells you about the intention, to the extent you can infer intention from the way that they behaved towards each other and as towards the property and their common finances. And for those reasons, you have to be very careful not to place all of your focus on contributions and fairness, which quite often I see family lawyers in particular, when they move into the area of looking at Tolata type claims, focusing probably far too much on what has been done by way of contributions and where fairness may lie in the light of the way the parties have run their arrangements, rather than the focus on intention, which is really what's key, because detriment without intention, as we will see, is likely to not be determinative of the claim, with a slight distinction in relation to proprietary estoppel that we'll come back to in a short while. So we're just going to very quickly just do a review of the different types of cases that may well come across your desk. And as I say, for most cases where a property has been bought in joint legal names, the likelihood is that now there's going to be an express declaration of the beneficial interest within the TR1 that the parties signed when they had the property conveyed into their joint names. Doesn't always follow that the relevant boxes have been completed, but more often than not now the TR1 is completed with an express declaration of trust within it. And the case law since the 70s has been pretty clear that where you have an express declaration of trust, that is, as a starting point, and in most cases the end point, conclusive proof of the ownership. And that applies whether the parties are married or whether they're not married, as Goodman and Gallant made clear. The fact that the parties then separate and the relationship breaks down doesn't alter the arrangements that they agreed and the declaration of trust that they entered into. And although it's possible to sometimes seek a rectification, rectification is pretty difficult. To get rectification of an express declaration, you have to show by fairly convincing and coherent evidence that what the trust that the parties have signed says is not what they actually agreed or intended it to say. And of course, in most cases, that's going to be pretty difficult to prove unless you've got some very clear instructions that were given to the solicitor on the conveyancing file, which are recorded through correspondence, which for whatever reason didn't find their way through into the express declaration. Where the express declaration is in the TR1, usually there's not going to be any real issue over the construction of what the trust is, but clearly where there's a more involved trust document, a trust instrument which declares the trust, there may be issues as to what exactly the parties intended it to mean, particularly if it's something other than a straight joint tenancy suggestive of equality. And in those circumstances, the court will apply the usual rules of construction, and the leading cases now are the Supreme Court decision in Wood and Capita Insurance Services, and also there's another example of a case in Gasper and Zaleski as to how the court looks to construe a document, bearing in mind that there are limits to the extent to which the court can go beyond the plain wording of the document itself. But even if you've got an express declaration of trust, there may be cases where events subsequent to the purchase of the property amount to an estoppel, which we'll come back to in a moment, or a further constructive trust because of what the parties have agreed, and particularly what they've done to their detriment based on that agreement. But if there's no alteration to the declaration of trust or the terms upon which the property is held by reason of something like that, then essentially your only way of adjusting the way that the proceeds of sale are going to be divided is to see whether there is some equitable accounting, which may well require an adjustment away from the straightforward starting point of 50-50 to deal with further contributions or transactions that have taken place in relation to the property. So moving on to situations where you've got co-owners named on the legal title, but for whatever reason, there is no beneficial declaration of ownership. So in other words, the TR1 box 10 has simply not been completed with any of the boxes ticked, or there is some other reason as to why the property has gone into joint names legally, but without the beneficial ownership being addressed. And that may well be the case because the property was purchased a long time ago before the TR1 became standard in 1998. Well, the law, as you know, from Stacking Down and onwards, says the starting point presumption is that a purchase in joint names means that the property is probably also owned in equity in joint names. Then, in order to displace that starting point presumption, you need to find evidence to show that in fact something else was agreed. And the perhaps revolutionary aspect of Stacking Dowden was to say that when you do that, you apply a whole course of dealing review, which means you look at everything which the parties have said and done in relation to the property and trying to divine from that what their intentions were. So in other words, you're looking for, from their words and actions, what their intention was as to how they intended to share the property, it being taken as read that the fact is in joint names means that they were intending to share it. Now, an interesting development we've seen this year is the case of Hudson and Hathaway, which addressed the question of whether detriment is required in a case where the property has already been conveyed into joint names, or is it enough to say that there is an agreement between the parties as to what the ownership is without showing that there's any detriment based on that agreement. Now, that was a case where after separation, the parties agreed in a series of emails what the division of the equity in the property was going to be. And that effectively changed from being an equal joint names situation to one where the division of the proceeds would be unequal. And the question the court had to consider was whether detriment was actually required for the emails to create a new constructive trust. And Mr. Justice Kerr, sitting in the Queen's Bench Division, took the view, having looked again at Stacking Dowden, that in fact the Supreme Court didn't mention detriment as being required in a joint names case, and he formed the view that detriment wasn't required. The agreement by itself was enough. Now, is that correct as a statement of law? There has been fairly loud and vociferous criticism, particularly by academics, that that is a break from orthodoxy on the basis that a constructive trust has always been assumed to require not only an intention, but some degree of detriment relying upon that intention. And the statement, therefore, of Mr. Justice Kerr and Hudson and Hathaway is regarded as being somewhat unorthodox and heretical. Now, he did also, in any event, in that case, find, well, even leaving aside the question of whether detriment is required or not, he did find that there was detriment in that case. So whether an appeal is actually brought, given that finding of fact, remains to be seen. But there is the scope for that case to go to the Court of Appeal and for the Court of Appeal to consider whether, in fact, what Mr. Justice Kerr said is correct in that case. And certainly I would flag a contrast to a case which on the facts is not dissimilar from Hudson and Hathaway, which is Ely and Robson, where it was held that detriment was required to give effect to a post-separation agreement which was made between the parties, although the facts aren't entirely square with each other. So an interesting development, one which at this stage we can't entirely resolve, and we'll have to see whether the Court of Appeal gives some further view on that. But then continuing on our journey through the different types of trust, because unfortunately now the law makes these distinctions between what may be required depending on the circumstances of the case you've got. So we've dealt with express declarations of trust, we've dealt with co-owners on the joint name title of the property. And leading on still from dealing with cases with the co-owners that are jointly named on the legal title, the court has held in Jones and Kernott that even if the court isn't able to find that the parties formed an intention at the time of the purchase of the property as to how they would own it, the court can now retrospectively, in a joint names case, look back and see if it can impute an intention to the parties based on what they have done with the property and how they've acted in relation to the property since. In other words, rather than looking at what was agreed at the time and the evidence of what happened afterwards to see if you can divine and infer what was agreed at the time of the purchase. This is a backward-looking review where the court accepts there was no intention. If the party had been asked at the time when they bought it, what are you intending the ownership, the beneficial ownership to be, they would have said, well, we haven't even considered it. We haven't formed an intention. And so in those circumstances, the court is now looking backwards to see what would the parties in fact have thought was fair, looking back now at everything they've done in relation to the property, which of course, again, is a fairly novel and some would say heretical development in the law. So far, and we'll come back to this in a moment, imputation only works in the context of quantification of an interest. So in other words, it only applies in a case where there is a joint names purchase from which there is an inference that the parties intended to share the ownership. And the imputation on a Jones and Kernott basis is simply looking at the way they've dealt with the property since to divine what would be a fair allocation of the equity in the property. Whether it can be used in sole name cases, we'll come back to, and at the moment the answer in relation to that is not a positive one. So then we turn to the more difficult areas, which is where you've only got one name on the legal title. And for a long time, since 1991, the law was pretty clearly set out in the case of Lloyds Bank and Rossett in the House of Lords, which established that there is effectively a two-stage process. One, you have to prove there was an intention to have an interest. And secondly, the court then has to try and identify what that interest should be. And two types of cases arose under the Lloyds Bank and Rossett scenario. There were those where there was evidence of express discussions or agreements. So in other words, one party said, although we're buying it in my name, this is going to be our joint property, or something along those lines. And type 2 cases where there was no such evidence of any discussions. And in fact, the court is simply trying to see if it can infer some degree of common intention, albeit unspoken, between the parties at the time of the purchase. Whether you're dealing with type 1 or type 2, the law has always been pretty clear. The detriment is required in a single name case. And that detriment has to be in reliance upon the agreement or the common intention that the parties founded at the time. So when Lloyds Bank and Rossett was decided, the House of Lords were pretty clear that they were very doubtful that anything less than a direct contribution to the purchase price would be sufficient to raise in a type 2 situation the inference that it was agreed or intended that there was going to be a sharing of the property. And the court took the view that anything other than direct contribution was unlikely to give rise to an inference of a trust. Now in Stack again, the House of Lords completely reviewed that law and changed it and said that the law has moved on since Lloyds Bank and Rossett. And in paragraph 63, Baroness Hale was pretty clear that she said she thought Lloyds Bank and Rossett had set the hurdle rather too high. And then in Abbott and Abbott, a decision of the Privy Council, it was again made clear that Stack and Dowden had got rid of the need for a direct contribution to be proved to the purchase price or to the payment of the mortgage, and said that in fact now all the law required was a search for a common intention based on the whole course of conduct in relation to the property. So not merely direct contributions financially, but everything that was done looking at the way the household was run in the round. Now, Jones and Kernott, that I mentioned earlier on, dealt with the imputation of a common intention in relation to the quantification of shares in a joint names case. But within the context of the discussion in that case of the law, their lordships, or at least two of them, Hale and Walker, respectively made comments as to whether it could be used to deduce from conduct or to impute rather than deduce an intention to actually own the property beneficially in joint terms, even though the property was registered in the sole name of one of them. Now, they didn't go so far as to say that the law should now make that leap. And indeed, Lord Wilson was very careful to say that's a question, because it didn't arise directly for decision in that case, that would require merit, or rather would merit careful thought. Well, the Court of Appeal has subsequently been asked twice to make the leap, which the House of Lords, the Supreme Court, wasn't prepared to make. And in both Cape Horn and Harris in 2015, and then Barnes and Phillips a little bit later in 2015, the court was very clear that imputation cannot be used in a sole name case to impute an intention that was not there at the first stage of the analysis. It can only be used at the stage where, having established that the party did intend to share the ownership, the court is then determining what that ownership should be, having found that the parties didn't really address their mind to how they were going to share the ownership. They simply made the first step conclusion that they were buying it jointly with a with the intention of sharing it, but with the quantification to come later. So is that the end of the story? Well, certainly this side of the Supreme Court, it appears to be for the time being. I certainly wouldn't put much money on the law changing in that respect significantly. And to many intents and purposes, the difference between imputation and inference on the facts of most cases is probably a very slender one. So that's the law as it deals with domestic dwelling houses, so the home of the parties. And Stack and Dowden was very clear that the resulting trust principle, which followed the idea that the ownership reflected the shares, rather the contributions each party had made in monetary terms of the purchase of the property, no longer applied in the domestic dwelling context. And that appeared to be pretty much the death knell in cohabitation cases to resulting trusts. But in Lasker and Lasker in 2008, it was suggested in the Chancery Division that perhaps the resulting trust analysis would still apply where you were looking at a property which was purchased not to be the home for the parties to live in, but was bought for investment purposes. And of course, that raised the question as to, well, where do you draw the line between what's a family asset and what's an investment? So, for example, a property which is purchased as an investment to provide funds by way of rental income for the family, well, how do you really distinguish that from something which is purchased for family purposes rather than purely for investment purposes? Well, in any event, the Privy Council in Marr and Colley said that the Stack presumptions will apply in any event in terms of investment property, and the search is still one for intention. But with that said, it does seem that many judges are still very much influenced by contributions and by the resulting trust analysis, because it has a degree of simplicity about it. And so we can see two cases where the court was looking to determine what beneficial ownership of a property was, and in both Secretary of State for Work and Pensions and Tower Hamlets in 2018 and in Wojcicki in 2017, the court basically followed a resulting trust analysis rather than a more holistic assessment of what the common intention was. And likewise with companies, we've seen in cases like Petrodel and Prest that the resulting trust analysis carried the decisive decision in terms of the ownership of a property, because in that case, Mr. Prest had provided the funds for the purchase of a property, and therefore it was deemed that Petrodel had, although they held the legal title, held that on a resulting trust for Mr. Prest. So that's still a rather woolly sort of area of law, but largely you should probably work now on the basis that the Stack approach, which is to look at the whole course of dealings in order to determine what the parties' intentions were, is really where the law has now travelled to, and is the direction which their lordships in the Supreme Court expects us to take in most cases. So moving on from constructive trust now to proprietary estoppel. Now, these are claims which is generally a fallback to a claim under constructive trust. In most cases, you will use constructive trust as your primary analysis if it's available to you. But these are cases where there isn't necessarily something very clear in terms of a common intention or an agreement in relation to the acquisition of an interest, or where the interest which is being claimed is something short of a beneficial interest in the property. So in other words, something like a life interest to use or live in property, or some other sort of benefits that flow from a property based on statements such as, don't worry, you can live in this house forever, or one day it'll all be yours, or something else that's rather more vague than simply saying, we are buying this property now as a joint property between the two of us. So it's a close relative to the constructive trust. And indeed, at one point, about 10 or 15 years ago, the Court of Appeal came close in a few decisions saying basically they're opposite sides of the same coin and there isn't really any difference between them. But in fact, the law now has made again a clear distinction between constructive trust and proprietary estoppel cases, and it is now a different species with a slightly different test for it. So if you're relying on it, which you may well do in some cases, you need to actively plead it as the alternative to constructive trust. And when you plead it and when you're advising a client on it, you need to have in mind the three basic questions that give rise to the equity under proprietary estoppel. So the first thing is whether an equity is established. And for that, there are three basic ingredients. There has to be either an assurance or some sort of promise or other state of mind being formed knowingly between two parties. Based on that state of mind or promise or assurance, there has to then be reliance, and that reliance has to be to the detriment of the person who's claiming the equitable relief. Now, having established through those three things that the equity prima facie exists, the court then has to consider, what's the extent of that equity? And the cases now have had to wrestle with the question of balancing the benefits that were received as a result of whatever's happened between the parties with any detriment that has been suffered, to see whether in fact the detriment is really significant. And then ultimately, having considered the extent of the equity, the court will then decide what relief to grant. And the court has said that that should always be set at a fairly minimal level, the minimum equity which is required to do justice. And that raises the question of how is that to be calculated? Because you may well have a very large promise, such as a promise to say, if you carry on working on this farm for the rest of my life, when I die, it'll all be yours. But the detriment in relation to that may be quite small, because somebody may have still been paid for working on the farm and had other benefits from it. So should they then receive the full weight of the promise, or should the relief that they receive be more proportionate to the detriment that they've actually sustained in relation to it? And the direction of travel in the law now seems to be one that's governed more by looking at the equity that's required in order to alleviate the detriment and to set justice in that right, rather than focusing as a starting point purely on the promise and giving weights to that. So bear in mind this really important difference between a proprietary estoppel and constructive trust, particularly if you're dealing with a situation where there is a claim being made against the property through bankruptcy or by some other means, such as that, by a third party. Because constructive trusts exist from the point when the circumstances that give rise to them exist. So constructive trust gives a proprietary right, makes somebody a beneficial owner of a property, right from the point when the circumstances first gave rise to it. And all the court is doing in the proceeding is declaring the existence of that right. It's not creating the right. The right already exists. Proprietary estoppel is quite different, because proprietary estoppel is an equitable remedy where there are no rights in existence until the point in time when the court actually makes the order and grants the relief. So in other words, the court giving the equity at that stage, rather than there being a pre-existing right which the court is giving recognition to, as in the context of a constructive trust. And that can be very important in certain circumstances. For example, where you're asserting a claim against a trustee in bankruptcy where an owner of property has gone bust, because the proprietary estoppel may well not provide a great deal of relief in those circumstances compared to a constructive trust, which is a pre-existing proprietary right. Leading cases I'm not going to deal with in any detail. You have to bear in mind that, particularly with proprietary estoppel, cases are immensely fact sensitive and devoted to their own facts, because the court is considering the issues of detriment, assurance, and everything else in the round very much as a very fact-based specific assessment in that case. So although the basic principles are particularly stated well in the cases that I've highlighted there, Thorner and Major and Davies, which contains a very good summary of the law and the legal principles, which has been applied and adopted in other cases since. When you look at these cases, they are all just examples of how the court has dealt with the estoppel on any particular facts. And it's that for that reason alone that proprietary estoppel tends to be the thing you fall back upon if constructive trust can't bring you satisfaction, or where the proprietary estoppel evidential basis is really clear, so that it's fairly obvious what the court's going to do in the light of it. Otherwise, in those more borderline cases, because the assessment is so finely tuned and so finely based on the facts as the court may find them to be, it is really difficult to predict how a court is going to deal with the proprietary estoppel. It may not find the right established, or even where it does find the right established, it may actually grant a relatively low level of equitable relief in return for it. So there have been cases where the promise seemed to suggest that somebody was going to be able to obtain an asset outright, being a valuable farm, and in fact all they've been granted is a fairly short period of occupation before they have to vacate the property. So we move on then from those quantification issues, just to have a very quick update on where the law with illegality is. So for a long time, the law was set out in Tinsley and Milligan in 1994 in the House of Lords, which established effectively the reliance principle, which said that you can't rely upon illegal conduct that you have entered into in order to assert a right. So if, for example, the reason for putting a property into one person's name rather than into joint names was in order to be able to claim benefits by the person who, state benefits that is, by the person whose name didn't appear on it, because that was an illegal purpose, one couldn't then use that as a reason to explain why constructive trust is given given rise. But in other circumstances, there could be illegality, but somebody would then gain a benefit from it. So, for example, somebody could have made a large contribution to a property, not have their name go on it. The reasons for the transaction being structured in that way was in order to ensure that benefits could continue to be claimed and a legal purpose, and the person whose name went on the title would therefore have unjustly benefited despite a very large contribution being made by the other party. So being rather arbitrary in terms of which party was asserting the right and how it would work out, ended up with a fairly messy situation where the judges were often trying to find ways around the Tinsley and Milligan principle in order to try and do justice to the facts of the case. So in Patel and Mercer in 2016, the Supreme Court looked at it again because they were reviewing one of their own previous decisions, or rather a decision of the House of Lords. They sat as a 9-panel Supreme Court and they basically overruled Tinsley. They abolished the reliance principle and have now set up a more discretionary test, which is that illegality doesn't of itself automatically defeat a valid claim, but the court can, based on illegality in its discretion, refuse to offer the equitable assistance that would otherwise arise under constructive trust or under proprietary estoppel. But the court made it quite clear that the cases where illegality utterly defeats a claim were probably going to be quite rare. And the court set out a list of factors that had to be considered, and you'll find the tests, including a test of proportionality, set out at paragraphs 101, 107 and 93 within the judgment, but the court was quite clear to say that wasn't a prescribed list. The court had to do an assessment of all the circumstances of the case. It has to be said that's not necessarily met with everybody's approval, and certainly Lords Mance and Sumption in their dissenting judgments said that they found the new test far too subjective and preferred something that was clearer cut than the current approach is. But it certainly means that illegality is no longer an automatic bar, and in fact in many cases will now not really be an effective defence to a claim which is being brought in constructive trust or proprietary estoppel. Now, I said at the beginning we'd also touch on what you do with assets that are not property, i.e. residential property, and in Whitlock and Morey, although dealing with joint bank accounts, it gives you a clear steer that the most senior judiciary and the Privy Council in that case were taking the view that the Stack and Dowden principles basically applied regardless of the category of the asset. So in the context of a joint bank account, the banking mandate is effectively the equivalent of the TR1, and you look at to see what was agreed within that. And if there's no express declaration, then you're looking at all of the parties' dealings in relation to that particular asset and perhaps the wider way that they've dealt with their finances during the course of their relationship to determine what their intentions were as to the ownership of that particular asset, being a joint bank account or being any other asset that was purchased during the currency of their relationship. Now, equitable accounting, often a rather mystifying subject, and many lawyers have often struggled to understand exactly what equitable accounting is or how it applies. In essence, it is the court being able to, having found that the ownership of a property is joint or in whatever proportions the parties agreed, to then make adjustments for things that have happened typically since separation, but sometimes even during the course of the relationship. So most commonly it'll be if the parties have separated, the property hasn't yet been sold, there may be a charge for the occupying party for the use of the property by way of occupation rent. If only one party has been paying the mortgage and the other has not been contributing, there may need to be adjustment for that. And likewise, if one party has made substantial payments towards the improvements to the property, that may also justify equitable accounting. Now, the old equitable principles were set out in a series of cases which appeared to be utterly displaced by Stack and Dowden, which, particularly in the context of occupation rent, said that now Talata section 15 applies, and that allows the court, through the virtue of sections 13 and 14 of Talata, to determine what the occupation rent scenario should be and to allocate it accordingly. So effectively leaving aside the old common law principles, the old equitable principles, and replacing them with a statutory base. It's fair to say I don't think that point was even argued actively within the hearing in Stack and Dowden, and it was just a paragraph or two at the end of Baroness Hale's judgment which suggested this total overthrow of the existing law by reason of the 1996 Act. Well, in Amin and Amin, shortly after Stack and Dowden was decided, the Chancery Division judges said, well, actually the two regimes coexist rather than one replacing the other, and both can apply depending on the circumstances and how the court determines to exercise its discretion. And Davies and Jackson, if you want to see a more recent example of how it's being used, is a case where an insolvency has arisen and somebody was still in occupation of a property, but you can see the various principles, particularly in terms of mortgage payments and occupation rent, being used in that case. So in terms of the most often occurring elements of equitable accounting, we have occupation rent. It used to be thought that in order to be able to claim an occupation rent, there had to be an active action of ouster, where somebody was excluded from living in the property. More recent case law has made it clear that actually a breakdown in relationship, which means that it's no longer tenable for both parties to continue to share the property, will often amount to a situation where one has effectively been deprived of the opportunity to live in the property and the other one has therefore benefited from it. So the ouster requirement is certainly softer than it used to be. And then the issue is, what do you quantify by? Is it the notional rental value of the property, which you would probably have to make an adjustment for in any event, given the tax isn't being paid on the occupation rents in the way that it would be paid on a genuine rental value? Or is it the cost that the other party has incurred in relation to providing alternative accommodation? Well, again, it's going to depend on the circumstances of each case and what the court deems is fair, but you certainly need to have evidence before the court if you're asking for this adjustment to be made through equitable accounting of what the occupation rent ought to be, so be it a market rent or be it the costs of the alternative accommodation. Mortgage payments, should capital and interest be taken into account or only one or the other? Well, the test is, generally speaking, that both payments need to be taken into account. There used to be a basic approach that was often taken as a rough and ready rule that the mortgage payments offset the occupation rent. But that was certainly pre-2007, 2008, when we had higher interest rates, and the difference between what people paid on their mortgage and what they paid in relation to rent, or would have paid in relation to rent, wasn't so great. Certainly for the last decade, with low interest rates, it's been the case that a rental value of a property was almost certainly higher than the amount of mortgage payments that were being paid on the property. That may now be changing because of the way interest rates have gone recently, but the court will still take a view as to which is the appropriate way to do it. More often now, it will do the analysis of both the mortgage payments and the occupation rents and do an offsetting calculation appropriately. Again, you need the evidence in relation to that. Cost of improvements, the law is that generally you take the lower of either the increase in value or the cost of the works. So if the works cost 20,000, but they've only added 10,000 to the value of the property, the 10,000 is what goes into the equitable accounting, and vice versa. If 10,000 pounds worth of works of the property will improve the value by 20,000, then the higher figure, the lower figure will still be taken in relation to that. Again, it's not a rule of absolute rigidity, and there's scope to argue it, but at the very least, you're going to need to have the evidence of both figures so the court can do its analysis. Normally, the court won't embark on equitable accounting in relation to anything that was done between the parties during the currency of the relationship, but there may be circumstances, and if you look at Wilcox and Tate, you'll get some clues to when they may arise, where even pre-separation, the court may take the view that there were things that were done that need to be taken into account as part of an equitable account. But I made the point already, you need to get the evidence. Often equitable accounting is raised only at a final hearing without there being any evidence which allows the court to do the assessment. You really need to have that built in to the evidence that's presented to the court. Related to, but different from the issue of equitable accounting, is something that's quite useful, which is the equity of exoneration. And it applies where a debt is charged against the property, but the beneficiary of that debt is only one of the parties. So an example might be where somebody has borrowed against a mortgage, rather than those funds being used to augment or improve the property, it's been used entirely for the purposes of one party, for example, to pay their debts or to invest in a business of theirs or some other venture. And the basic principle that was stated in Re Patortu is that where that arises and one person alone has had the benefit of the debt, albeit the fact that it's expressed against the property as a whole, will in fact only be applied against their share of the property. So in other words, the mortgage, rather than coming out of the equity of a property before the equity is divided 50-50, will actually be taken off one party's 50% share, where the court takes the view that the equity arises. Now, in Lemon and Chorder, the point was made that it's rather artificial to simply look at who used the money, and one has to stand back and take a broader view of things. So in that case, the money was used for the funding of the husband's business. So strictly speaking, he was the beneficiary of the funds, but it was that business which was providing the income which allowed the parties to run the household budget. And so in that situation, the court took the view it wasn't fair to allow the wife to take the benefits of the prosperous lifestyle that came from the business without taking the burden of the debt that fed into the business that provided that lifestyle. Now that suggested there could be something of a death knell to the principle, but in Day and Shaw, Morgan Jay said no, in the right circumstances, it can still be used. And more recently, we've got Graham York and York, which says, again, looking at Pitortu, looking at Lemon and Chorder, what one now has to do is stand back, and rather than looking at just nominally who the money was used by or paid to, one has to conduct a whole course of dealing review as to whether it is fair to apply the equity of exoneration, and if so, to what extent. And the most useful case now is probably Armstrong and Oniaro, which makes clear that although there may be cases such as Lemon and Chorder where indirect benefits do prevent the equity of exoneration applying, it's not an automatic bar to the equity applying that you've received some indirect benefit. A more holistic assessment is required. Overseas property, just really quick touch on. Equitable rights, in other words, beneficial interests in property, are deemed in law to be rights in personam rather than rights in rem. And therefore, the court has the right in England, so long as the parties themselves are subject to the English jurisdiction, to make declarations as to the ownership of property in the beneficial sense, regardless of where that property is located. So if the parties have invested in some way in property in France or Italy or in the USA, and they have, as English citizens and residents in this country, formed an agreement in relation to that which the court would recognise as a trust, then the English court will deal with that declaration of trust, notwithstanding the fact that the property is located in another location, in another jurisdiction. But certain rights are in rem, and they're related to the property. So, for example, an order for sale is deemed to be a right in rem. And so the English court will not make an order for sale of a property which is located overseas. That is a matter which falls within the jurisdiction of the lex situs, the law of the state where the land itself is situated. Sale to a beneficial owner. The powers which the court exercises under Talata are stepping into the shoes of the trustee who owns the property. And a trustee who holds the legal equity, the legal title to property, does not have the power or the right to tell one beneficial owner to buy or to sell to the other beneficial owner their equitable share. So therefore, in Raneba and Rabari, it was held that there wasn't a power to order a sale from one beneficial owner to another, which of course is strictly right. But what's been confirmed in subsequent cases like Bagum and Chasten is that what the court can do is still make an order for sale, which is something which the trustees who hold the legal title to property can do, and then direct the trustees to accept a first offer or a best offer from the other beneficial owner to the property. So in other words, giving them a right of first refusal. And that may even mean that it's not necessarily the very best value that the beneficiary has to pay in order to buy out the other beneficiary's share. What was stated in Chasten to be the requirement is that it simply has to be the best price, which is reasonably obtainable in the circumstances. And under the rules, PD 40D of the CPR includes specifically provision for the court to, within an order for sale, give permission for one party to bid for the property in the event it's sold by way of auction. Right, so with a few minutes to go at the end of the seminar, we're going to just briefly run through procedure. There's far more slides here than I'm going to be able to cover, so some of them you'll simply have to refer to in due course. For many of you, I imagine, calling in to this webinar, the civil procedure rules aren't your normal habitat. There is some really important stuff to bear in mind, particularly if you haven't used them for a long time, which is the very significant reforms that were carried out as part of Lord Justice Jackson's review of civil justice back in 2013, which has given proportionality a far higher status, as we'll see in due course, in relation to the application of the rules. And it's made very clear that sanctions, whether imposed by the rules or by the court, have real bite, and the court is expected to give weight to them. And something which is always present in the CPR, but certainly has been restated, which is that the risks of costs as a result of the way the parties litigate, and particularly Part 36 offers and whether they achieve their objectives, are very real. So in terms of sanctions, the basic principle is comply or apply. In other words, comply with the rule or the court's requirement, and if you can't, make an application as soon as it becomes clear that you're not going to be able to comply for an extension of time, because the sanctions are fairly broad and they're throughout the rule. So, for example, if you serve a statement of case late or a statement of evidence later than the court has directed, your case could simply be struck out, or your ability to call that witness to give evidence could be refused. Now, Rule 3.9 is what sets out the test for relief from sanctions. So if you haven't managed to make an application before the time limit expired and been given an extension of time, so in other words, you failed to comply with the rule, you would need to apply for a relief from the sanction. And the court has said that the court needs to consider all the circumstances of the case, but within the considerations, the court needs to look at the requirement for litigation to be conducted efficiently and proportionate to costs, and to enforce the compliance with the rules, the practice directions and the orders. So it's much stronger than the rules that existed pre-2013 in terms of what the test is for relief from sanction. So in a series of cases that flowed from it, particularly Mitchell and News Group newspapers, which was the Conservative MP, Mr. Mitchell, who was suing the newspapers for what was published about his comments towards a policeman at the gates of 10 Downing Street. In that case, the lawyers who acted for him, having issued the claim, failed to serve a cost budget by the time limit that was required by the rules. And the effect of that within the rules in terms of the sanction is that you are then only entitled to recover, if you win the case, the costs of issue, none of the legal costs that your lawyers have incurred. And in Mitchell, the court took the view, well, there wasn't a good reason as to why the cost budget had not been served, and therefore that sanction was not removed. What followed from that was a series of cases where the rules were effectively applied incredibly rigidly, with relief from sanctions being granted in very few cases. That caused the Court of Appeal to review the law again in Denton in 2014, which somewhat softened the test and made it clearer, as we'll see in a moment, that actually relief will be granted perhaps more readily. And really what the court needs to look at is to have a proportionate view as to what the gravity of the breach is and what the effect of injustice of applying the sanction would be to, or granting relief would be to each party. And it's also important to note, quite helpfully, earlier this year, Park and Hardy has made clear that although normally a Part 23 application with evidence is required where you're seeking relief from sanctions, in certain circumstances, the court will be able to grant relief either of its own motion or by way of an oral application, which is particularly useful where you're at a hearing and an issue has arisen as to sanctions and you are finding the progress of the case thwarted. The court may be, in the correct circumstances, entitled and prepared to grant relief despite the fact that you're making the application in the face of the court. But the court's made it clear that that's not something which you can expect to be routinely exercised. It will only be exercised sparingly in the interests of justice. So the Denton test is now effectively threefold. First of all, is to identify what the seriousness of the breach is. If it's not a very serious breach, a very technical breach, relief is likely to be granted. The court will want to know why the default occurred. Obviously, the better the mitigation, the more likely it is that relief is going to be granted. And then the court has to stand back and look at all of the circumstances of the case, with particular emphasis on what Rule 3.9 says. And it's also been stressed that lawyers have a duty to further the overriding objective, and that means not taking opportunistic procedural arguments. If somebody is a day late, inconsequentially over complying with a direction, which has no real effect on the bearing of the case, it would probably be unreasonable of them to stand in the way of relief from sanctions being granted. And indeed, where somebody unreasonably objects to relief from sanctions, they may well find themselves on the wrong end of a cost order themselves. The way the Denton test is applied will often depend on which court you're in. So if you're in the High Court dealing with civil judges, you may well find it's much more strictly enforced than it is if you're in a court where the judge who's hearing the case is more used to dealing with cases on the family procedure rules and is more relaxed about things. So it's unfortunately not entirely consistent, but the best policy, as I've said, is comply or apply. Don't put yourself in a position where you need to be applying for relief from sanctions. But if you do, then still make the application as quickly as you can. Just pretending it hasn't happened and hoping it'll all be all right in the end may actually be compounding the issue. Helpfully, the Supreme Court's made clear that litigants in person are just as required to comply with the rules and including relief from sanctions as anybody else. Only if the rules are particularly obscure or inaccessible might the court give them greater flexibility or leniency than it will do to legally represented parties. But bear in mind that there are some express exclusions from what LIPs have to do. So, for example, electronic filing of documents is something which they're not required to do in the business and property courts, and cost budgeting likewise is something which they're exempt from. So pre-issue, before you start any case, there's a general principle that litigation should be a last resort, so therefore the court will expect you to follow the pre-action protocols, which effectively mean sending a letter of claim with relevant documents before it and responding to that claim, and then narrowing the issues prior to starting proceedings. And if you don't do that, there could be sanctions and costs and repercussions later in the case. So unless you actually urgently need to start proceedings in order to obtain injunctive relief, normally you should follow the pre-action protocol first. You're also expected to reasonably engage in mediation. And in Halsey back in 2004, the court made it clear that there was expectation the parties would mediate, but it was accepted the court couldn't force them to. But in the more recent case of PGF2 SA and OMFS, the court made it clear that even if a party has a strong case, even if they succeed at trial, if they have refused to negotiate through mediation early on in the process, the court may well not award them all of their costs incurred in the litigation, despite the fact that they won. So simply saying we think we've got a strong case, we want to go to court, is not a reason not to mediate. So if you are refusing an open invitation by the other side to mediate, you need to really think carefully about what your reasons for that are, and make sure they're clearly documented at the time, so that you'll be able to convince the court in due course that the decision you made was reasonable. Which court are you issuing in? Well, the family courts and the county court are no longer one and the same. They're different courts with different jurisdiction. Talata, or indeed 1975 Act proceedings, are not family business within the meanings of the rules. They're civil claims. Therefore, they are deemed to be chancery business. Therefore, they need to be brought in either the High Court or the County Court, and the family court has no jurisdiction to deal with them. As I say, you may end up being heard by a court, a judge who sits in the family court regularly, but he will in fact be hearing the case in the High Court or in the County Court, because it is not possible to have them heard in the family court, unless and until the rules change. Cost budgeting is something which, of course, for family lawyers, you won't see very often. The rules are set out in CPR 3.12 and 3.18, and also in Practice Direction 3E. If you are involving yourself in this type of work, it's important you understand them, because they're so critical now. They apply to all multi-track matters under £10 million, which are on Part 7, with only limited exceptions, but most contested Talata applications are going to be caught by these rules. The parties, but excluding litigants in person, must file a precedent H, not a form H, as I've seen mistakenly done in the past, but a specific form for setting out the cost budget in precedent H, which is with the CPR. That has to be done 21 days before the case management conference, has to be signed by the lawyer, or if there's a directions questionnaire and a claim for less than £50,000, that's when you send it in rather than at the CMC date. And prior to the CMC, you are required to have a discussion with your OPPO and put together a budget discussion report, which is filed with the court. If you fail to file the budget, as I mentioned in relation to the Mitchell case earlier on, the sanction is that you will only be able to recover, if you win the case, the issue fee. That is all you'll be able to get back. So if you spend £100,000 fighting the case for your client will only recover the £400, £500 or £600 issue fee they paid when they started the case, which is obviously pretty damaging. Once the budgets are in, the court can make a cost management order. That order records the parties' agreements, records the approval of the court if the costs haven't been agreed, and it records the agreement of the costs that have already been agreed. Now, the important relevance of cost budgets is that when the court comes around to assessing costs on the standard basis at the end of the case, the court will not normally depart from what the budget that was set at the beginning of the case states. And so if there is if you've agreed or approved a budget, you will only recover those costs that are in that budget. And for that reason, if the case changes shape during the currency of the proceedings, you have to make sure you review your cost budget to make sure they are up to date and still reflect the costs you're likely to incur in the proceedings. Cost capping is also something which you can have, although it's pretty unusual. So if you can try and agree the budget with the other side, because the court's not entitled to revise or change a budget which is agreed by the parties, and quite often the parties do agree the budgets for that reason, but the court can still make comments on the budgeted costs even if they're agreed. Different courts in different places will deal with this with the different degrees of rigor. Some centres are fairly relaxed, some are going to do it almost like a detailed mini assessment. And bear in mind, the budgeting is prospective. It's looking to the future costs. It doesn't affect the costs you've already incurred in the proceedings up to date. And if the case changes, I've already made the point, make sure you review the budget as you go along. Disclosure, I'm not going to deal with very quickly. I'm not in any detail deal with very quickly, because you need to be aware of the fact there's now a new menu of disclosure options, which spread right from there being power for the court to say no disclosure at all, to have varying degrees of disclosure, or to make a standard disclosure order, which is what everybody's always grown up as being used to, or indeed just making a bespoke order in the proceedings, which is new for that case. In multi-track cases, there's a requirement to provide reports on the disclosure you anticipate carrying out in the case, including the costs of doing that. The parties are expected to discuss that beforehand, and the court will then consider how it deals with the disclosure. If it's agreed, you may well approve it even without a hearing, otherwise it will give directions accordingly. May order disclosure in stages. There's the power to give pre-action disclosure. And bear in mind also, this is really important, that if you don't disclose documents within your disclosure documents, then you won't be able to rely upon them later on in the case, unless the court gives you permission, and the Denton sanctions relief provisions apply in that sense. And electronic document questionnaires, again, is something which you need to now wrestle with, because so much information is held electronically, and the court expects the parties to give an assessment of how they propose to deal with the potentially very voluminous information that comes out of electronic disclosure. But when you're issuing in the High Court, so the Business and Property Court, as the Chartered Division and the specialist courts around the country are now known, there is a specific pilot which is in place there, which may well become part of the main rules in due course. I'm not going to go through that, but you need to familiarise yourself with that if you are issuing in the High Court, because whatever CPR say, this new rule now, which is within PD 51U, prevails, and you'll need to follow that procedure instead of what the rules state in the disclosure sections. Witness statements, the Denton relief will be required if you don't serve it on time, because the court will not allow you to call that witness without relief from sanction. You need to make sure the statement is very complete, because certainly in the civil jurisdiction, judges don't generally allow lengthy cross-examination, and may well not allow any, examination in chief, may not allow any examination in chief whatsoever. So if there's important evidence, make sure it's in the statement. Don't leave it to be led orally. And that's pretty much what the rules say about that. And also bear in mind that judges are particularly sensitive now to statements that are drawn up by the lawyers rather than by the parties or by the witnesses themselves. Overly lawyered statements are probably going to be criticised, so you should ensure that your witness evidence is confined to the facts, and as much as is possible, put it in the witness's own words and language, and that's particularly important where it's being taken through an interpreter. There are various powers of the court to limit and to control evidence, including putting limits on cross-examination. You've got the power to ask for notice to omit facts. You've also got this very important provision, which is that where a document has been disclosed, is presumed to be authentic unless you take exception to it earlier on. So it's no good turning up at trial saying, we don't accept this as an authentic document, if you haven't raised that issue beforehand, or again, you're going to be relying on seeking Denton relief from sanctions. Hearsay notices should be used if you're relying on hearsay evidence. Don't just stick it in without complying with the formalities of the rules, and Part 33 sets those out. And bear in mind that if a document goes in the bundle, it's admissible. So do be careful of parties slipping into a bundle documents which may not have been disclosed, or which you challenge as to admissibility, because the prima facie position is, if it's in the bundle and you've agreed to it being in the bundle, then it is admissible unless you take exception to it. And given that there are no page limits on civil bundles, it is a fairly common trick to try and slip documents through that way. So you do need to be alert to that. Cost rules have been heavily revised as well, part of the Jackson reforms in 2013. The general rules are still in Part 44, and the basic principle is that although the court has a general discretion, it will generally ensure that the loser pays the winner's costs. The court then considers the conduct, degree of success, and any offers that have been made, not including Part 36, which has its own set of rules that you need to be familiar with. And conduct, as I mentioned earlier on, includes pre-proceedings conduct. So failures to enter into negotiations or mediate may well have an adverse consequence, even if you win the case, because you may not recover all of your costs. Now, the basis of assessment has changed, and this is really important to understand, because the standard basis now allows costs which were previously, those costs which you showed were reasonable, you can now recover them only if they're proportionate, which means it may be the case that it was reasonable to incur them, but the court can take the view that it was disproportionate to the issues in the case, and therefore they can be disallowed, even though you show that it was actually perfectly reasonable to take that step in the proceedings. And any dispute about that is resolved in favour of the paying party, which means you now have to keep a really close eye on making sure the costs you're incurring on behalf of your clients are proportionate to the issues in the case and the value of the case, because if they're not, you may well find not recovering the case. The indemnity basis is still there, and that proportionality of law doesn't apply in that. But of course, the cases where indemnity costs are going to be ordered are relatively few and far between. So normally you're going to be caught by that proportionality test under the standard basis. And it can bite quite hard, because proportionality is measured as to the reasonable relationship to the sums in issue, most importantly. So if you incur costs of £100,000 arguing about £50,000, clearly proportionality is going to be brought into relief. If it's not a money claim, it will look at the value in equivalent terms of non-monetary relief that you're seeking. But it will also look at whether you've had to be incurring extra costs because the other party to the proceedings has behaved unreasonably, and that therefore is added to your work. And then the court will look at the wider factors in the proceedings as well. But a good example of how harsh the proportionality rule can be is the Brian May case, where he sued for damages as a result of building works going on near his home, which he said caused a nuisance. In the end, he ended up settling the case for a fairly low sum, and his costs were something in the region of £200,000. In the end, the court assessed his costs, despite the fact finding that actually a lot of those costs were reasonably incurred, took the view that the overall cost was disproportionate, and he recovered well under half of the costs that he'd incurred on the case. So he was actually out of pocket at the end of the litigation compared to what he'd spent on it. So you do really need to keep a really close eye on proportionality when you're dealing with any of these cases now. FDRs didn't used to exist under the CPR. What the court in the civil jurisdiction used to do is often apply a stay, which would allow the parties to go off and mediate or to seek an FDR neutral evaluation. But since 2015, the CPR do have built into it early neutral evaluation, as it's called, and the court can direct the parties to do it. They don't have to consent to it. The court can actually require them to attend an E&E neutral evaluation, or for the court to hold a private FDR, a court FDR of its own making. And Lomax made it very clear the parties don't have to consent to that step being taken. So for that reason, settlement meetings, mediation, and private FDRs are now encouraged by the court, and can indeed be pushed on the parties. And bear in mind, if you don't engage in such efforts, having been invited by the other party or by the court to do it, that could have adverse consequences in costs, even if you succeed in the proceedings overall. Bear in mind, particularly from the family point of view, that hearings for these sorts of cases will be in public. They feel like family cases. They deal with disputes over a relationship breakdown and the consequence of that financially, just as a divorce case do. But the court will, unlike family proceedings, default to sitting in public rather than in private. One option you, of course, do have, if you want to have privacy, is to arbitrate instead. And that was a point made by Mr. Justin Austin in W&M. Bear in mind, if you're not going into private arbitration, then any evidence which is given through a statement which is accepted as evidence in chief in its written form can be inspected by the media or by any member of the public who wants to, and that can open up a whole level of scrutiny of the parties' finances and their arrangements, which is not particularly welcome. So just to have that in mind, and it also applies to other documents that are filed and referred to during the hearing, such as skeleton arguments. So arbitration has all of those usual benefits: being quicker, having the expertise of a tribunal, feeling more like a family court, not having all of the sanctions of Mitchell and Denton, and being private as well. So do think about that seriously as an option and discuss it with your client before you embark on the court process. But of course, if the other side don't want to agree to arbitration, ultimately you can't force it any further than trying to raise it with them and see if they'll agree. But the benefits should really sell themselves to both parties. So that was the quick gallop through, I promise, and I'm a little bit over time because I hadn't quite factored in the introductions earlier on. I was working on taking about an hour. If you've got any questions, I'm happy to take them now, but I appreciate probably people's time is exhausted. So if you have anything to raise with me, my email is available on the end of the slides. It is also available on my website, and I'm more than happy to receive any questions that you may have directly to you. And I've seen nobody's post any during the course of the talk itself, so I'll leave you to follow up with me if you want to in due course. So that concludes my presentation. Thank you very much for your attention. As I say, if there is anything now, please raise a hand or put it in the chat. But otherwise, I'll take it as a compliment that everything I've said makes perfect sense and you don't have anything further to ask.
Thank you very much, Andre. Oh, there's just one question that's come in. Let me just see who that is. Someone's raised their hand. It's Ken. I'll allow Ken to talk now, Andre.
Sure.
Ken, if you could unmute so we can hear you. Your microphone's now on.
Sorry, it's not really a question, but will copies of the slides be available?
Yes, I'll make sure they're sent through to the administrators and they'll circulate them to the attendees. So yes, I'll make sure they get around to you.
Thanks very much.
No problem.
I think John's just joining us back, perhaps just to close things off. But thank you very much, Andre, from Surrey Law Society.
Yes, thank you, Andre. I think we've got a question from Ken Galati. Let's see if
we've just dealt with it, John. It's all right. We've done.
Fantastic. Sorry, yeah, lost connection. So can I just thank you, Andre, very much for this fantastic talk. I'm sure everybody was very, very interested in that. If Helen hasn't already said, there is a link that will be sent to you about this session with a recording of it, which you can look at again if you need to. Please, can we ask for feedback on the session or anything to do with the Surrey Law Society in terms of their general programme for CPD events? Please send those to helen.opie@surreylawsociety.org.uk. And if there are any other questions, then please ask them while we have a few more moments to think about them. I'm not seeing that there's anything else now. There's a few people dropping off, but nothing in Q&A. I think we can probably say thank you once again, Andre, and finish the session.
Thank you, John. Thank you, everybody, for attending.
Brilliant. Thank you very much indeed. Bye-bye.